Sir Priyanshu Mishra.
Priyanshu, you have to introduce yourself.
Sir, myself Priyanshu Mishra. I have I have brought up.
Are you comfortable in Hindi or English?
For English. I'm comfortable. Myself Priyanshu Mishra. I have brought up in Varanasi, Uttar Pradesh. I have completed my initial education from Central Hindu Girls School. I have completed my bachelor's in law from Banaras Hindu University.
Then after?
So then after this, in 2021, I have completed my LLM from Banaras Hindu University. Recently.
What is your specialization at LLM?
The commercial law.
And what is topic of your presentation?
So interim measures and arbitration.
How do you think that this specialization in commercial law is going to help you in your performance at civil judge level?
So if you go through the various the contents of all the various subjects that are included in the commercial law, like Sales of Goods Act, Companies Act, and Contract and Partnership, they all are day-to-day life of a businessman's life, and they also include the civil matters. And if you go through the subject area that was included in the Bihar Judicial Services, it also include a proper paper with regard to the commercial law. It also have part and parcels with regard to sales of goods, partnership, negotiable instrument act, and companies. So it will somehow, it will not in all the parameters, but it will help me to enrich my knowledge in judicial services also.
Suppose you have to write a judgment. What will be the essential contents of judgment? Judgment writing is one of the aspects.
Yes. So it will include first of all the name of the court and the name of the name, description and name and description of plaintiff, as well as name and description of the defendant. The issue or the violation of the issue is there, and the claim of relief that has been provided by the court. And if it is with regard to any set off or counter claim has been done in the issue, then it will include. It will also include the date in which the judgment has been given.
How correction in the plaint can be made?
So in correction in the plaint or pleading, sir?
Plaint.
Plaint. So in the correction in the plaint will be made. Party will apply to the court with regard to any correction. I don't properly remember the provision with regard to correction in the plaint.
On what basis plaint may be summarily rejected?
Sorry, sir.
What is the liability of prosecution, burden of proof of prosecution in criminal cases?
So, the burden of proof in prosecution to establish the case beyond reasonable doubt.
Whether there is any exception to it?
Yes, so there is an exception. If we go through Indian Evidence Act Section 105, if any accused is taking the plea, that whether he comes under the general exceptions of IPC or any other exception with regard to the provisions, then here the burden of proof shifted to the accused. He is required to prove that his case come under the general exceptions.
When right to private defense in case of body will extend to causing death.
Yes, sir. So it is given under Section 100, and it has some certain ingredients when the right of private defense can be extended to causing death of the perpetrator. First of all, it includes an assault of. It includes an attempt to cause apprehension of death or grievous hurt. It includes unnatural lust, wrongful confinement, whether the measures to take the help of the public officer cannot be taken, and attempt. One more thing there, I might be missing it. Not properly.
You have to differentiate between hurt and grievous hurt.
So hurt is provided under section 219, and it say that if any pain or any injury has been caused to the body of a person, it's said to be hurt. Grievous hurt include ingredients whether when a hurt can be said to be grievous. First of all, there is permanent imperation of the either side of the eye. Second, if there is any imperation in the either side of the hearing abilities, dislocation of bones, permanent dislocation of bone with regard to impairing the power of such bones. If the person is hospitalized for 20 days and he cannot do his all the natural daily routine, he is unable to do. Yes.
Is hospitalization necessary?
Sorry, sir.
Is hospitalization necessary for the second ingredient?
So for the last ingredient, hospitalization is not necessary, but he should be injured till such an extent that for the days of 20 days he is unable to do his routine work. A properly day has been mentioned. It might not be less than 20 days.
What is the difference between preparation of robbery and preparation of dacoity?
So, in preparation of robbery and dacoity, basic difference will be the number of the persons. In robbery, there might be one person or two, but in dacoity, there always be required more than five members. Robbery, dacoity is just an aggravated form in the form of the number of the person who commit the robbery.
Whether preparation of robbery is offense?
No, sir. Preparation of robbery.
Preparation of dacoity.
Yes, sir. Preparation of
That is the basic difference.
Okay, sir.
अखबार तो रोज निकलता है, डकैती की योजना बनाते पकड़े गए, तो बड़ी पॉपुलर न्यूज है। बाघ को घेर लिया, डकैती की योजना बनाते पकड़े गए, कभी बाकी नहीं निकलता। That is the basic difference. Why, with regard to certain offences, this burden of proof has been reversed? For example, with regard to NDPS, with regard to Terrorist Deputies Act, this burden of proof is just reversed.
So it can be the NDPS Act or for the terrorists. Here a presumption has been made by the law that says act strict liability rule will be applicable. That if the person is doing the act, then it must be punishable. And here the absence mens rea is presumed to be there. Prosecution is not required to prove the case. Here it is presumed that act must has been done, and if the accused is required to prove himself innocent, then he is required to prove that he was by mistakenly or by any conspiracy or any compel or force has been done upon him, as a result of which he has been done such certain act.
You have completed your dissertation on arbitration.
Yes, sir.
Whether this arbitration can be applied in case of criminal liability also?
No, sir. Arbitration cannot be applied in criminal liabilities.
In any form?
Yes, sir. In any form.
There is no chance.
No, sir.
There is no chance of settling the dispute between the parties either with or without the help of mediator, arbitrator.
So, mediator is a different part and arbitration is a different part. Arbitration is always done between the parties, and in mediator, third party is included.
In arbitration also third party is included?
Yes, sir. Third party is...
So, in arbitration act says that odd number of arbitrators should be there.
Yes, sir.
How arbitrators are appointed?
So, with regard to
suppose number is 3.
Yes, sir.
How arbitrators are appointed?
So, if we see, first of all, that we have said that odd number of arbitrators. Section 10 says that number of arbitrators should be odd. Section 11 talks about appointment of arbitrator. It says that each party will appoint a single arbitrator, and the appointed arbitrator will appoint the odd one arbitrators.
Okay. Suppose they are appointing odd number, even number. Then what will be the fate of that arbitration?
So, even number couldn't be appointed because a proper express provision has been given.
Okay. in violation of express provision, they are appointing even numbers.
Okay, sir.
What will be the fate of arbitration?
So then again, a party will either the party will apply to the High Court with regard to appointment of an arbitrator. It has been given in section 11, subsection 3.
How? What is said to the decision of arbitration?
So arbitration will be in force as per CPC.
What is the technical name?
So award.
Award. How award can be set aside?
So award can be set aside under section 34 of Arbitration Conciliation Act. It can be raised by either the party that both the parties have not been properly heard, a proper duration has not been fulfilled, and fraud has been committed by the parties. And this application is to be made within 3 months of passing of the award. And it can be extended till 30 days more, but not more than 3 months and 30 days.
Can you explain vicarious liability?
Yes. So vicarious liability is a concept which is based on the that whether if the person is liable for the act of another person, and it talks about the respondent superior. Here, if the relationship between the parties can be of principal and agent, or the partnership among the partners, there can also be vicarious liabilities. In vicarious liabilities, always required that there should be a contract, and contract of employment should be done. But independent contractor cannot be said to be servant, and in an independent contractor case, vicarious liability doesn't apply.
Is it applicable in matters of criminal liability or in criminal cases, criminal matters?
Yes, sir. Under section 154 and section 155 of Indian Penal Code, it applies.
What is strict liability?
Sir, strict liability rule basically has been came from the Redden versus Fletcher case. In this rule depends that if the person has done a certain act, then he is strictly liable for his act, even though he doesn't have certain guilty mind with regard to commission of an act. So proper definition is not there. I have tried to have it.
Absolute liability?
So absolute liability has came from MC Mehta's Union of India, as T.N. Bhagwati has talked with deal with. In absolute liability, so that there's absolute liability had just overrode the drawbacks of strict liability. There are certain exceptions of strict liability also, but absolute liability has no exception. And if the act has been done by the company any hazardous industries, then the owner of such a company is whole sole responsible for any calamity that has been happened.
Strict liability was also initially absolute liability.
Yes, sir. Exception, yes.
And exceptions were added subsequently
Yes.
By the court, by several prisoners. Can you explain the procedure of amendment of the Constitution?
Sorry, sir. Couldn't hear it. Sorry.
368.
Yes. So, with regard to there are certain amendment can be a simple majority and special majority, and thirdly talks about whether rectification by states can be done. Rectification of state can be done with regard to certain issues, whether with regard to judicial service, union judiciary, state judiciary, and whether the list, either of the list amendment has to be done.
Is there power of Parliament to amend the provisions of the Constitution?
Yes, sir.
Initially.
So the basic structure of the Constitution cannot be amended.
Is it let down in the provision?
It is not let down in the provision, but the Supreme Court case like Keshwan and Bharati case, it has been the amendment, the basic structure of the Constitution cannot be amended.
What do you mean by constructive prejudice?
So, constructive prejudicata is given under section 11, explanation 4 of sorry, civil procedure code. Is said that uh, claim or the issue which might have been raised in a suit, but which might or ought to have been raised in a suit, is deemed to be a directly substantially an issue with regard to the suit.
And deemed decree?
So, deemed decree is given under section 2, subsection 2 of CPC. Is say that if with decree is said to be deemed decree, if there is rejection of claim, and with regard to the application of the under section 144 of CPC with regard to substitution.
अगर प्लेन रिजेक्ट हो जाता है
Yes.
ऑर्डर 7 211 तो क्या इसकी अपील हो सकती है?
Sir, rejection of a claim, appeal cannot be made, but again a suit can be filed according to section rule 13.
इस पर res judicata का रूल अप्लाई नहीं?
नहीं, judicata का rule apply नहीं।
चलिए बहुत सवाल करना आपने कुछ प्रॉब्लम। मान लीजिए कि मैं आपको इंड्यूस करता हूँ कि मेरे पास ये जो सांप है आप कटवाइए, अगर आप कटवा लेंगे तो मेरे पास ऐसी दवा है कि मैं आपको पक्का बचा। आपने उसके लिए कंसेंट दे दिया और सांप से कटवाया और डेथ। क्या
Sir, culpable homicide. The inducer will be liable for culpable homicide.
yes.
So, because section 300, the last exception, fifth, says that if the consent is given by a person who is above 18 years of age and then death has been caused, then the perpetrator will be liable for the culpable homicide.
यहाँ पे कंसेंट फ्री होनी चाहिए, यहाँ कंसेंट देने के लिए मैंने इंड्यूस किया है तो भी culpable homicide?
No, sir.
अच्छा ये बताइए कौन से सब्जेक्ट से पूछे सबको बताइए।
सर, जो सही लगे सर आपको बेटर लगता है।
अच्छा अभी बता रहे थे तुम स्ट्रिक्ट लगी,
हाँ।
क्रिमिनल मामलों में स्ट्रिक्ट लगी थी तो क्या मतलब?
सर, क्रिमिनल मैटर्स में
No problem.